All right, the court will call the matter State of Wisconsin versus Ezra McCandless, Benton County case 2018 CF 125. It's day 4 of the jury trial. I'd ask the counsel state appearances, please.
Your Honor, the state appears by Dunn County District Attorney Andrea Nodolf and Assistant Attorneys General Richard Dufour and Peter Hahn.
Ezra McCandless appears in person and with her attorneys Aaron Nelson and Deja Vishnu.
All right, counsel, I have had an opportunity to read State versus Evans 187 with 2nd 66 on the issue of whether the state can introduce evidence of specific acts of conduct under 90405 subsection 2. And I'll have to say that without going through all the facts of the Evans case, I can't say that I necessarily agree with the case, but as a trial court, I believe that I'm obligated, required to follow the holding in that case. And in that particular case, I'll just boil it down to this, that the defendant, faced with only hearsay testimony introduced from a child sexual assault victim, without ever having the witness testify or be able to go into any issues of credibility on cross-examination, had asked to put in basically what I would consider to be 2 whopper lies that this young girl had told, and claimed that her character for truthfulness was an essential element of his defense. That basically his defense was that this young girl was untruthful. And again, not being able to cross-examine the witness, so on and so forth. There was an analysis of section 90404 and 90405 in relation to the federal rules of evidence. And the discussion on I believe it is page 81 of that decision, when they're talking about, from the federal rules, character may itself be an element of a crime, claim, or defense. And they refer to it as character and issue. And then they use illustrations. For example, the chastity of the victim under a statute specifying her chastity as an element of the crime of seduction, or the competency of a driver in an action for negligently entrusting a motor vehicle to an incompetent driver. What it seems to say from the court's perspective is that it truly has to be an element. And I know the argument from the state is that, well, once self-defense is put into issue in a case such as this, and I believe that based upon again, the opening statement of counsel and frankly, again, some evidence put in and so on, that self-defense, certainly no one would disagree. I don't believe that self-defense is an issue in this case. That then on a first-degree intentional homicide charge, that then the character for peacefulness essentially becomes, my poor word choice there, that character for peacefulness then is an essential element of a charge, claim, or defense. And again, even though I may disagree with the result in State versus Evans and the reasoning in that case, I believe that if I follow the guidance of that particular decision, I would have to say it is not an essential element that the state has to prove. The state has to prove beyond a reasonable doubt that the homicide was not in self-defense. It does not, as an essential element, that they prove that the decedent, Mr. Woodworth, had a character for peacefulness. And just like in that particular, in Evans, the court had said, and I'll just quote part of a sentence in the beginning on page 82, that Alicia's character for truthfulness might be relevant to Evans' defense. It was not an essential element of his defense. And again, while evidence of character for peacefulness is certainly relevant to the state's burden of proof in this case, I just can't find, in light of Evans, as a matter of law, that the character for peacefulness is an element, an essential element, and therefore the court, following that law, cannot allow specific instances of conduct to prove peacefulness or peaceful character or character for peacefulness, however you want to phrase it. And I'll just note also, and I'm sure counsel agree, that these issues of character evidence in 90404, 90405, as well as other aspects of when character becomes an issue, are some of the more complicated, difficult areas of the law. And so that will be the ruling of the court. Now, moving on to Court Fox, he can testify in the court's opinion again, because the court is going to find that the door has been opened again because of the evidence that was shown to the jury in the opening statement, and statements made in the opening statement about Mr. Woodworth being the aggressor, primary aggressor in this case, that certainly evidence of peacefulness of character, or the character for peacefulness of Alexander Woodworth, can be introduced under section 904.05, subsection 1, by way of reputation or opinion evidence. But again, following the court's guidance, I think that to make a correct decision, I think that is the correct decision. So that is the order of the court with respect to that. Now, with respect to getting into the journals of Alexander Woodworth by Court Fox, the court's provisional ruling gave basically a time limit to both counsel on this issue. The defense, I believe the ruling was 4 hours on this topic of the McMorris evidence related to his journals and so forth. However, the court also ruled that the state would have equal time to rebut that or refute that. And also in keeping in mind the rule of completeness, the court is going to order that the state may go into entries of Alex's journal that Court Fox is aware of or now aware of, if the state wishes to give context to these excerpts that have been used by the defense or may be used by the defense. However, Mr. Fox was not identified as an expert, and frankly, I think interpretations is going too far. I think giving context, other entries that were in the journal that would give context to what was said or may contradict or may express different sentiments or ideas. In fairness, in the rule of completeness, the state may do that. But I think we're getting on real shaky ground if we're starting to talk about interpreting what Alex meant. I guess leave it to, the jury to interpret. So we'll allow the state to go into that, but, and even if Court Fox gets into maybe some concepts or so forth, but just going to watch that line carefully in terms of when we get into areas of interpretation of what Alex meant. Now, that's all on that evidentiary issue. One other issue I have to bring to counsel.
Can I ask a question, Your Honor?
Sure.
Just so that I'm clear, because I don't want to run afoul of the court's rulings. I don't want things to go smoothly. For example, if counsel has referred to a small portion of a number of entries and attempted to use them to show that Alex has a character for violence. Can I ask him simply, are there other sections of this particular document or this particular journal entry which would indicate that this is not intended as a violent or an advocacy for violence or a belief that violence is appropriate? Is that permissible?
We would object to that as being an interpretation.
And that's why I'm asking.
Well, I think that's right on that line. I mean, I think, as a preliminary question, I don't have a problem with that, but then it just, you know. If you
And then just have them read the other
have the
sections.
passages or the excerpts.
Okay, that's fine. And that's,
Just so it's clear, the defense thinks that crosses the line. We agree that, and I've said from the beginning, if the state wants to put the entire journals in, we have no objection to that. We agree with the rule of completeness. I don't think it's necessary to ask any witness, be it Court Fox or somebody else, what Alex, if they ask, what is Alex's intent, that is an interpretation. And so.
No, I don't think that's what Mr. DeFore said. He said that, are there other passages or parts of this that would indicate the character,
that this is not an advocacy for violence.
Well, but that's an interpretation. I think he can say, are there other passages? Yes. Is this one of those passages? Yes. Could you read that passage to the jury? Yes. He gets to do that.
Well, here's the thing. I'm going to give him a little latitude on that because, if we keep objecting to a lot of little things, we're going to fall quite a bit behind schedule. Now, I understand it's important, Mr. Nelson, but
The law.
well, it is, but there's other aspects to this that this door has been opened, and so as far as the court is concerned, just a brief question like that, foundational question, doesn't cross the line. But I'm not asking for, not allowing his. Again, getting into his opinions and interpretations of specific portions, but if you say, he's responding to that question and then you point to specific passages and he reads those passages, I don't think that's crossing the line. So,
we may object, but I just want to note now that we are continuing objection regarding that. And I understand Your Honor's ruling. I'm trying to be make this go as smoothly as possible, but as you said, there's a fine line, and so I just want to make sure for the record, and Your Honor understands, it's a continuing objection.
All right, okay, so your objection is preserved as it relates to that. You've certainly raised an objection to it, and so things can go more smoothly while we have a jury in here. I'm not going to require that you make that objection at that time, maybe after the witness. Well, you indicate your objection, and then if it's consistent with what I've said here, I'll overrule your objection, but your objection will be preserved. Ms. Vishney?
Thank you very much, Your Honor. Your Honor, I'm not sure whether or not what I was going to argue this morning has been overcome by the court's ruling, but I'm assuming the court, based on what it said, is no longer going to allow the state to elicit evidence from Court Fox that Alex disclosed his views on self-defense.
Yes.
Okay, that's fine. This may come up in the context of other witnesses, I'm not sure, but I did some further research on statement of recent perception, and which is the hearsay issue as opposed to the character or relevancy issue. And I just am extremely confident that that statement and perhaps other statements with other witnesses, perhaps other statements of, do I need to use that?
Oh, sorry.
Yeah, other statements of other witnesses don't fall under that. And I don't know if the court wants to entertain that now. It's no longer really relevant to Court Fox, but I'm really not sure if something else is going to be elicited from any of these other witnesses. But
Do you have some authority?
yes, I certainly do.
Okay, if you could just
Judge,
slowly and deliberately.
yes, sorry. I would like the court to look at State v. Stevens, which is at 171 with 2nd, 106. And let me just say, in the case that the state cited, I was very focused yesterday on the passage of time between the making of the statement that the hearsay declarant makes. And in the State v. Stevens, it was 3 days. In State v. Manuel, it was almost instantaneous, or not instantaneous, but very close. They were about events. in State v. Weed, the case that the prosecution cited, the hearsay declarant had told a friend that he had taken all the bullets out of his gun. So he was talking about an event. In State v. Manuel, the hearsay declarant was talking about a shooting. However, State v. Stevens, in that case, just somebody just making a statement to another person doesn't qualify. It is what perceived. Can I read from the opinion? Is that all right? It's a little bit lengthy. It's about 4
Well, it is, but
paragraphs.
again, if we can get into that in more detail, and I don't know, is the state this morning, before we have a break, planning to introduce any more statements of Alexander Woodworth under hearsay exceptions?
I don't believe so, Your Honor.
Okay, then I'd like to hold that argument.
That's absolutely fine.
Any other cases that you want the court to review?
No, I think this is the main case that actually defines what that exception is, as opposed to talking about confrontation or length of time. Okay. So this would be the primary case.
All right, Madam Clerk, are you able to message Joseph and let him know?
Okay.
We need that case. Okay, because I don't want to keep the jury waiting. Here's the next thing I have to bring up, counsel. We lost one of our alternate jurors today, so we're going to be down to 13 jurors. And I'm not going to elaborate. My understanding is a medical emergency, a legitimate medical emergency, and one of the alternatives might be to wait and see whether the person will come around. But if this juror if we go ahead this morning and this juror doesn't hear evidence, that juror's out. Anybody disagree with that?
No, I would agree, Your Honor. If they don't hear everything, they should not be on the jury.
Now, if we get to a situation where, we have, and this is just, and I don't want to belabor this, but, if have somebody has something short-term, minor thing, we might have to maybe delay things for a little while so we don't lose another juror. But I think that's why we have alternates, so we're down to one alternate at this point.
I don't want to pry into the juror's personal business, and I can certainly understand the court not wanting to deal with it, but is this medical emergency something that's more than half a day?
Well, I don't know, but it did involve a 911 call and an ambulance, and so I think in the interest of privacy for the juror, I'm not going to elaborate beyond that because I don't know the specifics. But
Are you comfortable providing us now? I mean, we could do through deduction, but the name of the juror number, just so we.
The juror is. Juror number 144. I'll just give you the number.
That's fine.
You should have the material. You can tell what the name is from.
Somewhere we do.
What's that?
Somewhere we do.
Yeah. I just think the privacy of the juror.
Oh, absolutely. I think that's important. I've seen in long trials, even with starting out with 14, getting down to 11. And I mean, I've just seen it happen several times. And we're not going to agree to just have 11 people make a decision. So I am concerned, and that's why I asked that question, whether it was beyond half a day, because I think I'm sharing the court's concern about what happens later, and I can appreciate that at this juncture, the court wants to plow ahead.
Well, I know defense counsel has expressed concern about, not being rushed when it comes time to present their case. Time certainly isn't limitless.
Right.
We have.
I understand.
Yeah, I think we have ample time set aside for the trial, but again, we do have to be mindful of keeping things moving and not wasting time, because a little bit here and a little bit there, it really starts to add up over 3 weeks. So with that.
No, I agree, though. I do think we're calendared through November 6th. That's that's what I put in my electronic calendar, that we had cleared court through November 6th, which is 3 weeks plus 3 days.
Well, we have a little bit of, margin for there, but not, I don't believe through November 6th. That would require then some major reshuffling. So,
Okay, that's what I wrote, but
but let's not worry about
Yes.
that at this point. And we're going to try and get this going. So are we ready to bring the jury in?
Yes, Your Honor.
Okay. Let's bring them in.